An agent must have a working knowledge of contract law, because every aspect of the business deals with the contract. A contract is an oral or written agreement to do or not to do a certain thing. Many oral contracts are valid and enforceable. However, most contracts involving real estate must be in writing to be enforceable. The Statute of Frauds determines the documents that must be in writing to be enforceable. In most states, real estate documents, such as sales contract, deeds, and mortgages, must be in writing. Some states allow an oral listing for less than 1 year. But in order to be compensated, a brokerage firm needs an employment contract in writing to collect compensation. Therefore, it is in an agent's best interest to have a written listing agreement. When the phrase "time is of the essence" is written in a contract, it means that everything must be done within a specific time. An as-is clause in a contract means the buyer is buying the property as he sees it, with all the existing conditions. Now, the seller is still bound to disclose all property defects, but they are not required to make repairs. An assignment is the transfer of contract rights from one party to another. This could be the right of a transfer of right, title, or interest in a property. A contract is assignable unless the contract or state law forbids it. Personal service contracts are usually not assignable. The party transferring the contract is called the assignor, and the party receiving the contract is called the assignee. An assignment does not relieve the assignor from liability unless a novation has been granted. Novation is the substitution of one contract for another and releases liability. Just remember, nova is Latin for new, hence novation, a new contract. A liquidated damage clause is a contractual provision that determines in advance the measure of damages if a party breaches the agreement. In a sales contract, the earnest money deposit may be considered liquidated damages if the parties so agree. That is, if the buyer breaches the agreement, the seller may keep the earnest money. Specific performance is a court action to force the completion of a contract. For example, if all requirements of contract law have been met and the seller refuses to sell the property, the buyer may sue for a specific performance. Brokers do not sue for specific performance. The rescission of a contract occurs when there is an agreement between the contracting parties to waive all remaining duties and to terminate the contract. In essence, it would be returning the party to the same legal position they were in before entering into the contract.